This is a lecture for my professional responsibility class about ABA Model Rule 8.2, which is about judicial and legal officials. And I want to remind my students that there's only usually 3 or 4 questions about the Code of Judicial Conduct on the MPRE. Sometimes students take the MPRE and they come back and tell me, boy, I think there were a lot more than 4 questions about judges. Well, we have some model rules about the lawyer's relationship with judges. So you could have a question about 8.2 that's not a question necessarily about the Code of Judicial Conduct. So let's take a look at the rule. We kind of have 2 parts of this rule. First is about public statements that you make about the judge. The lawyer shall not make a statement that the lawyer knows to be false, or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, an adjudicatory officer, or so that could be an administrative law judge, let's say, or a public legal officer, or of a candidate for election or appointment to judicial or legal office. So you have someone who gets nominated to the Supreme Court and they're going through their confirmation hearings and you decide to kind of make up a story about them, that still would violate this rule. And I want to say something about this, about A before we move on to B. There will be times if you're a litigator where you get really frustrated with your judge, or you have a judge in a case who you feel like is being unfair or unreasonable, or is making mistakes, or is out to get you or something like that. I hope this doesn't happen to you, but there's lawyers who at times get very, very upset with the judge in their case. Resist the urge to take to social media or start writing angry editorials to the newspaper, attacking the judge and so forth. Lawyers do this sometimes and get themselves in trouble under this rule. So let's go back to the rule. There's another provision that we need to look at for a second, and that's B. A lawyer who's a candidate for judicial office shall comply with the applicable provisions of the Code of Judicial Conduct. So please note sort of a stealth Code of Judicial Conduct issue here that we could work into a question on the MPRE. So you have a lawyer who's not a judge yet, but they're running for a seat in a state with elected judges, like in Texas. While they're a candidate, they already have to comply with the Code of Judicial Conduct provisions. Now, the ones we're most likely to worry about are the ones about fundraising and kind of advertising and campaigning and political affiliation and stuff like that. So even while you're campaigning for a judicial seat, you have to be careful about not endorsing other candidates and about direct fundraising. We have had cases about this in recent years go to the US Supreme Court, and they have upheld the rules, the prohibitions. It was the case. One of the cases was about a lawyer who wrote to all of her clients in Florida asking them to donate to her campaign for a judicial seat. And that violated the state's judicial code. And she said it should be protected by the First Amendment. The Supreme Court said no. And note that it applied to her even before she was a judge. Okay. I need to, there's not a lot of interesting comments about this rule, but there is a body of case law, and I just want to tell you about the kind of landmark Supreme Court case. If you're one of my students, you don't need to know either of these. There's going to be 2 cases I want to talk about, one old one and one recent one. You don't need to know them by name, but you should be aware of these because this one, Garrison, is the leading case in this area. You'll see, if you start researching this, you'll see cited over and over again. So this is from 1964. Remember, kind of height of the Warren Court era. A prosecutor was convicted of criminal defamation in Louisiana. And what did this prosecutor do? This prosecutor had held a press conference. He was very frustrated with the local judges, and that there was this backlog, big backlog of pending criminal cases. The criminal cases took a long time, and he blamed it on the inefficiency and laziness and excessive vacations of the judges in New Orleans. Also said that the judges were refusing to authorize reimbursements for the prosecutors' undercover investigations and so forth. And it got pretty slanderous, right? I mean, he really made it sound like these are terrible people. corrupt judges. And the Supreme Court said that the First Amendment protects the lawyer from civil or criminal liability for derogatory statements about judges unless the lawyer speaks with actual malice. And so this is the rule that the Supreme Court crafted in 1964. If you have actual malice, and they define that as knowledge of the statement's falsity or reckless disregard of whether it was false or not. So, I mean, you didn't have actual knowledge, but there was no, you made an assertion that there was no reason for you to think it was true. And so you're just making stuff up, right? This judge is terrible. I bet he's, he or she is a pedophile or has a gambling addiction or is a drug addict. I've seen cases where lawyers publicly accuse the judge of being a drug addict or a drunk or something like that. And there's no reason to think that that would count as actual malice. Otherwise, our First Amendment rights do allow you to write an op-ed or a blog post saying, this judge, I would encourage everybody to vote against this judge because of this judge's decisions or track record on the bench is not good, and so forth. By the way, just going back to the rule for a moment, this applies to any statement, not just statements to the media. So this could be, we see this come up with emails, that angry emails that lawyers send to judges. It's still a statement, even though it wasn't publicly disseminated. So this isn't just statements to the press, though the Garrison case was about holding a press conference, trying to trash talk the local judges out of frustration. Here's a Colorado case from 2000. And again, there was some criticism, and this, how is this different? Remember, the prosecutor in Garrison was charged with a crime for criminal defamation. But what about just a disciplinary action against a lawyer? That doesn't necessarily implicate all the same legal issues. And so discipline for criticizing a judge is constitutionally permissible only if, one, the disciplinary authority proves a criticism was a false statement of fact or was a statement of opinion that necessarily implied an undisclosed assertion of fact, and the lawyer acted with actual malice, that is, with knowledge or reckless disregard of its falsity. And the reason I'm highlighting this case is it's just showing you all these years later the kind of the modern statement of the rule that was laid down in Garrison. So it does have to be a statement of fact. And so you saying as a lawyer, I don't like that particular judge, I really dislike, I hate having cases before that judge, that's not really a statement of fact. Now you may say, it's a fact, I hate that judge, but it's not something that other people can just fact check and go verify and so forth. On the other hand, saying, I'll bet this judge is addicted to prescription pain meds, that is a statement of fact that you need to know is true, or have some, at least have some evidence for before you make it. And I hope you can see the difference. Now, Rule 8.2a, especially in the comments, basically adopts the same standard for professional responsibility purposes that was laid down in Garrison. That's part of why I wanted to talk about the case in this video. And the same with the restatement of the law governing lawyers in section 114. Discipline is appropriate only for false statements that are made knowingly or recklessly. That's how they kind of sum up the rule. And if you follow the disciplinary actions in this area, basically anything, disciplinary actions brought under 8.2 and its equivalent end up being packaged, evaluated under the Garrison sort of factors that we have. Okay, that concludes our lecture on Model Rule 8.2.